You've met our speakers. So as you can see on the screen, Jayne, Rachel, myself, and Peter, and we're going to take you through some key developments for today. And it's going to be fairly quick because we've got a lot to cover. So as you'd expect, we're recording this and that will be available very shortly afterwards. The Q&A function is available. Please put some questions in. We have built some time at the end to try and answer some of those questions. If you put your name to it and we don't get the chance to answer your question at the end, it enables us to follow up, so do that, please. When you leave, there'll be a pop-up, which is a feedback form. Lovely to have some feedback, please, unless you're just criticising our weather reporting abilities. Okay, so in January, in our in-house focus, as it says on the screen, invites out tomorrow. Mark and Abby will be talking on the 11th of January, and it's going to be a quiz. We didn't have enough quizzes during the pandemic, did we? So it's another quiz about significant contract law developments. So please check out that and look out for the invite. So what are we going to be talking about today? Well, Jayne's going to kick off with a case law developments from a commercial perspective. I'm going to give you some top cases and a bit of what's coming through. Pete's going to talk to you about data protection, and then we're going to finish with Rachel talking about the without prejudice developments. Now, does that sound enticing, everybody? Yeah. I'll take that as a yes from my fellow speakers, and the cheer that I got from the audience that just didn't quite come through convinces me that we should get cracking. Thank you everyone in advance, and I hope you enjoy the webinar. Jayne.
Thanks, James. So I'm going to talk about two notable cases from a commercial contracts draftsperson's perspective. These might actually feature, I've got no prior knowledge, in the quiz that's going to go on in January. So listen up, because you might be able to get top scores. First case I'm going to look at is around limitation and exclusions of liability clauses. So one of our favourite focal areas as commercial draftspeople. And the other case I'm going to look at is force majeure, because of course, several years ago, clients tended to think force majeure was boilerplate, but not so much anymore. So let's turn quickly to the first case. So this is the case of CIS General Insurance against IBM. CIS is part of the cooperative group. Fundamentally, what happened was CIS engaged IBM to develop a new insurance underwriting system. IBM actually was quite heavily dependent on a subcontractor, and there are some interesting issues in the case around the use of subcontractors, which time doesn't allow me to go into. But the fundamental issue here was around a wrongful termination of contract and the way the exclusion of liability clause was interpreted. So this was a high value contract. It was worth around about 180 million, split over an implementation phase and a sort of business as usual management phase. There was an exclusion of liability, and then there were also separate caps on liability for the implementation phase and the business as usual phase. Fundamentally, what happened was CIS were very unhappy with some of the things that happened during the implementation phase. And therefore, when they received an invoice for close on 3 million, they decided to dispute it and withhold payment. What IBM then did was terminated the contract on the basis of that disputed payment. As this case unfolded, really, it uncovered a Pandora's box of issues, let's say. So, in the first instance, the High Court said that IBM had wrongfully terminated the contract because the contract allowed IBM to terminate for undisputed non-payment, but not disputed non-payment. When it came to the issue of the exclusion of liability clause, James, I don't know whether I might have put this up on the, thank you very much. This is what the exclusion of liability clause said. Basically, excluding liability for indirect or consequential or for loss of profit, revenue, savings, data, goodwill, reputation, etc. So the question is, did that clause act to exclude IBM's liability for wasted expenditure, which was a significant part of the damages claim that CIS were claiming? And the second question was, if that clause didn't exclude wasted expenditure, which cap of liability applied? Was it just the cap for the implementation phase, or did the cap for the management phase also kick in? So, interestingly, the High Court decided that wasted expenditure was excluded, despite the fact that wasted expenditure was not listed. And the rationale for the High Court making that decision was that it said, oh, well, we think that actually loss of profit can be interpreted as including wasted expenditure. Of course, CIS were not happy with that decision, so they appealed. And what did the appeal court say? The appeal court looked at the construction of that exclusion of liability clause and said, IBM's liability for wasted expenditure is not excluded. The rationale for that was the principle that you need to look at the actual words used and the construction of the actual words used. They observed that that exclusion clause listed lots of heads of loss, but it did not list wasted expenditure. And on that basis, IBM was liable for CIS's wasted expenditure. That then brought them on to the second question, which was, well, what cap on liability should apply to that? And what the Court of Appeal decided here was that the only cap that was relevant was the cap of liability for the implementation phase. CIS, of course, were arguing that it was the implementation phase cap and the management phase cap. But the Court of Appeal said, no, this project never moved beyond the implementation phase. And it was quite clear that the project lead decided this wasn't going to move beyond the implementation phase. And therefore, that additional cap on liability is irrelevant. So what lessons can we take from this? Fundamentally, when you are drafting an exclusion clause, you need to think very carefully about the heads of loss that you are looking to exclude. And if you are looking to exclude wasted expenditure, you should identify that. And during the course of negotiations, because of course we all know limitations and exclusions of liability clauses are negotiated heavily, you should think about a discussion and a negotiation as to what wasted expenditure might include, and at least a thought process for your business as to what wasted expenditure it might incur if the contract doesn't go according to plan. There were some other interesting pieces considered in this case, including set-off rights and also provisions around subcontractors, but time doesn't allow me to go into those. But if you have a spare hour, this is a case worth having a good look at. The second case I'm going to talk about is around force majeure. So this is the European Professional Club Rugby against the RDA television organisation. And I would say that there's an appeal outstanding on this case at the moment. The primary issue in this case was around the operation of the force majeure clause in a media rights agreement. The background to this is the EPCR had granted rights to RDA to stream several competitive rugby matches over several seasons. The media rights agreement contained a force majeure clause. Notably, the definition of force majeure did include the word epidemic. But the two notable clauses relevant in the force majeure clause are, go on, James, read my mind. that firstly, there's no liability for either party if a delay or failure is caused by a force majeure event. And secondly, a termination right, allowing the party not affected to terminate if the force majeure event continues for more than 60 days. So what happened here was, of course, this agreement was entered into the end of 2019. By March 2020, the pandemic hit, and the EPCR notified RDA that they wouldn't be holding matches due to the pandemic. They then issued a subsequent notification saying, so that they notified RDA in March. In April, they notified them, okay, this is continuing. We don't quite know when we're going to be running these delayed matches. We hope it's sometime by the end of the season, but we're not sure. In May, in June, the RDA notified EPRC that they were terminating the media rights agreement on the basis of that 26.4 force majeure termination right. The EPRC said, this is a repudiatory breach. You weren't entitled to terminate. And by the way, you also owe us some fees. The RDA obviously said, no, that's not right. And there was a claim made by the EPRC. So what did the High Court decide here? The High Court essentially decided what EPRC were arguing was, we're the party affected by force majeure, but you, RDA, are also affected by force majeure because nobody can do anything because of the pandemic. And that means that on the construction of 26.4, you are not entitled to invoke that termination right. And interestingly, the High Court gave that very short shrift, because they said, actually, both parties can rely on this clause. The fact that the RDA are also affected by the pandemic does not stop them from relying on that clause, because that clause is around the party who, the affected party is simply referring to where obligations to perform sit. They don't preclude RDA from terminating. So that's an interesting thought process, and a thought process that we all ought to think about when we are drafting those force majeure mechanisms. The second argument that the EPRC ran was that the RDA could not terminate because no notice of the occurrence of a force majeure event had been given. So there was a clause at 26.1 which set out a mechanism for the party affected by a force majeure event to notify the other party of the force majeure event. And the EPRC said, we didn't give you notice under that, and therefore the 60-day termination right, the 60 days hasn't started running. And again, the High Court gave short shrift to that, because it said the mechanism at 26.1 doesn't set out the form or the content of the type of notification to be given, and therefore the fact that the EPRC told them back in March that it wasn't going to be able to run the matches in accordance with the timetable was sufficient notice for the purpose of 26.1. So lessons from this case, I mean, this is a reminder, and I expect lots of you are already very familiar with this, but as a matter of English law, there isn't a concept of force majeure. So you have to have a specific clause that deals with what we consider to be force majeure events. And the other lesson is just thinking about pandemic and epidemics, and of course all of the other world events that are going on at the moment, and thinking very carefully about how you define what a force majeure event is. Now, of course, this depends on which side of the fence you're sitting on any supply contract, because on the one side you will want a very narrow definition, and on the other side, if you're the party holding most of the performance obligations, you will want a wide definition of force majeure events. But again, this is really a reminder to think about the mechanisms that you deploy in a contract and how you define force majeure events. And I think that's enough from me. So I think I'm handing over to you now, Peter, aren't I?
No, it's to me.
Sorry, James. Well, there you go.
Clearly, my presence lingered in your mind so long that. Anyway, so this is going to be a 10, 15 minutes on top 4 cases, bill of legislation and stuff that's coming through 5 bills, as it says there. There's a warning here. I'm going to cover 4 cases: Bathgate, Harper and Brazel, Mackereth and Somerville. 2 cases I would describe as difficult, because there are no easy solutions, of which Bathgate is one. One is worrying, and the other demonstrates how to deal with the clash of rights. Okay, I'll explain more as we go through. So let's start with Bathgate. This is one of the difficult decisions. So this is about how effective settlement agreements are. So we use settlement agreements day in, day out in the employment world. I'm sure that you do too, and you work with your HR colleagues in that respect. Mr. Bathgate signs a settlement agreement, and he's going to get a redundancy payment, and he appears to be promised an additional payment, and that's linked to a separate collective agreement which has a age limit in it. The settlement agreement settles age discrimination. However, after he has signed the settlement agreement, the employer goes, there's an age limit on this, and they apply the age limit, and it means he doesn't get the additional payment. He's not very happy about this and seeks to bring a claim. At tribunal, they say, no, I think not. You've settled claims for age discrimination. You're not going to get anywhere. And he goes to the Employment Appeal Tribunal. And the Employment Appeal Tribunal even say, not sure about that. Was that claim for age discrimination actually in his contemplation when he signed the agreement? Answer, no. So whilst it was listed in the list of claims being settled, he wasn't aware that there was a claim. It would appear potentially that the employer either does do something or fails to do something which disentitles him to do it. Whether or not that is disingenuous or not, it sort of feels like that. So to my mind, it feels like the right decision by the Employment Appeal Tribunal to not have him settle a claim which he expected to get, but the employer has done something after he signed which deprives him of it. So the logic is there. The issue is, for us all, is actually then how effective is the list of claims in the settlement agreement? We all know when we sign a settlement agreement, it's not 100% effective. Nothing is 100% effective. COT3, so ACAS conciliated agreements, are seen as more effective than a settlement agreement, but day in, day out, as I say, we use settlement agreements. So this is difficult because it's putting more flexibility, perhaps, or a chink in the armor of a settlement agreement and the list of claims, and therefore you have to, when using it, say it's not going to be 100%. I think it's slightly a fact-specific claim because of what the employer does after Mr. Bathgate has signed the original settlement agreement. And as a coda to everything, Mr. Bathgate was a merchant seaman, and that's outside of the remit of the Employment Relations Act and the Equality Act. Therefore, he couldn't bring the claim in any event. But when does that actually happen? And that's a side issue. Okay, now I'm going to come to the most difficult claim or case here, which is the Harper and Brazel decision. Now, I haven't got time to give this proper attention, but my colleagues Andrew Secker and Kate Watkins a couple of weeks ago did a whole webinar just on this case. So if I whet your appetite by talking to you about this and you go, I need some more information, contact us and we can send you a link to that recording. Now, this is all about interpretation of working time regs and holiday pay. Brief facts, Ms. Brazel worked as a hourly paid clarinet teacher. So she worked term time, basically. So she'd work the terms, no fixed hours, but she was employed for the year. And what the employer did here was at the end of each term go, well, we're going to pay you 12.07% of your termly earnings as holiday pay. Now, previously, that was seen as, that makes sense. If you look at an employee's entitlement to holiday, which is 5.6 weeks in the year, that works out as 12.07%, and that's been around for a while. However, she brings a claim when this comes through and says, I'm not getting paid enough holiday. And this goes all the way up to the Supreme Court, and the Supreme Court says, yeah, we agree. And it's rather put the cat amongst the pigeons. Why has it put the cat amongst the pigeons? Because it's basically saying, if you have people who have no normal hours, you have to look at their pay arrangements across the year now. It was 12 weeks, now it's 52 weeks. And you have to say, actually, they're entitled to 5.6 weeks holiday. And if they're entitled to that 5.6 weeks holiday, that means that they may be entitled to higher holiday pay, depending on how the averaging calculation goes. The last point on the slide is the key point here is we've had a huge number of requests from clients saying, what do we do? It primarily applies to hourly paid employees on a permanent contract who have different hours, so no normal hours. And they are likely to have more holiday and a higher rate of pay, but you need to look at how that works. I am very conscious I am skating over some quite difficult points here. The problem is there is no silver bullet. There is no solution to, oh yeah, we'll just do this. And that's why it's a difficult claim. There are ways of looking at this, and you could adopt a different process. The Supreme Court went through all of the points and said, this is rough justice, but this is how we believe the working time regulations should be interpreted. So it's the Supreme Court, so it's good law. And subject to a point I'm going to come on to about new legislation, it is what we need to deal with. So it is complicated, I'm afraid. I'm going to move on from Harper and Brazel and talk to you about Mackereth, which is the clash of rights claim. So some of you may remember the Mayor Forstater claim, which was by her. She had some controversial views, and ultimately she won at tribunal and on appeal in how we deal with that. The Mackereth claim was decided originally before Forstater, and then on appeal was heard afterwards. Now, this is quite fact specific, so I'm just going to take a moment to take you through this. So Dr. Mackereth was, find my notes, a medical doctor, and he had been engaged by the DWP, the Department of Work and Pensions, in order to work as a health and disabilities assessor. He carried out medical assessments to establish entitlement to disability-related benefits, and the view was he would come across various transgender service users in that time. So during his induction training, it emerged his religious beliefs clashed with the DWP's policy to refer to service users by their preferred titles and pronouns. He made it clear from the outset that he couldn't do this because of his belief in the infallibility of the Bible, in particular certain passages in Genesis and Deuteronomy. You might, if you're inclined to, put a Harry Potter gag in that Harry and Ron are not liable, or they are liable because it's Deuteronomy, but I wouldn't undercut this with a Harry Potter gag. So he was of the view, I can't address people by their preferred pronouns because it goes against my beliefs. Now, they tried to see if they could put him in a different role so he wasn't going to be in that situation, but because of his inexperience, that didn't work. They worked with him. There was nobody who was saying, this is outrageous. There was no clash in the workplace. And they tried to establish their position, and ultimately they understood his position, but they asked him to reconsider. He said no, and he was then terminated after a month in post. Why am I spending some time on this? It's because this is a hot topic for everyone. The clash of rights is very sensitive, and we always need to get that right. The DWP get it right on this occasion. They are not just having a knee-jerk reaction, they have a clear policy on how to deal with this. They go through the various steps, they make it clear what the expectation is, and ultimately they're willing to explore alternative solutions. So they get it right. And my takeaway here is that if you are going to have this clash of rights in the workplace, and frankly, most workplaces are going to have some sort of clash of rights on either on this subject or something else at some point, we need to be approaching it very calmly, very clear policies, and work through it rather than just going, oh, X is right or Y is wrong. I hope that makes sense. And then the last case I'm going to talk about is the Somerville decision. And this is the perhaps high watermark of the swing we've seen over the last few years, which is more rights to more people more of the time. So this is about whether or not Mr. Somerville is a worker. So most of you will know we have employees over here who have all of the rights, genuinely self-employed over here who have basically none of the rights or very limited rights. And in between the 2 points, we have workers who have more rights than self-employed, but less rights than employees. And there are this people like who are a worker will have holiday pay and things like that as rights. Now, very briefly on the facts, Mr. Somerville was a panel member and chair of the Fitness to Practice Committee of the Nursing and Midwifery Council, and he had an overarching contract. But then he entered into separate agreements when he was sitting on a panel. No obligation on him to accept an offer. They said that they made to him to sit on a particular panel. So they say, would you do this panel? And he could say yes or no. And even if he'd said yes, he could subsequently change his mind. So really quite remote. So no real obligation on him to do the work that he would be paid to do. But if he did do the work, he would be paid. This comes up as to whether or not he's a worker. And the Employment Tribunal says when he sits, so not necessarily on the overarching contract, but when he has accepted a arrangement to sit on a panel, he is a worker at that point. You'd say that would be perhaps fact specific. But given that lack of obligation on either party, the reason why this case is important is that it is eroding that point about mutuality or obligation. We always used to think that mutuality or obligation, I'll have to do this and you have to do that in response, was always there. What the courts are saying here is actually it doesn't need to be there, just the obligation to do the work personally. If that is there, you can establish worker status, which is why I hope you can now see why I was saying, is this the high watermark for status cases? We are eroding all of those bits that perhaps we've looked at over the years and say, X is not present, and therefore that person won't be able to establish worker status. Those are being eroded further. Okay, let's move on to a bit of stuff that's coming through. Nothing that's really going to rock your boats, but fit notes can be signed off by more than just GPs. So certain nurses, certain medical practitioners can sign off fit notes for your employees. Great. There's an amendment to the employment agency regulations, which is more exciting because that deals with being able to put agency workers in when your other employees are on strike. So this is rather contentious. So it's coming in. The unions, I think it's Unison and one other, are taking the government to judicial review on this because we know some more legislation coming to try and deal with strikes, but this is about dealing with removing the prohibition on putting agency workers in when your main workforce are out on strike, and greater penalties on the union in relation to that. So really quite contentious. There was a grace period for right to work checks, which could be dealt with online, that ceased on the 30th of September. So it's back to being done in person. I have to say, slightly worrying perhaps is that at the end of next year, there is so-called sunset provisions. And this is where the government is basically going to say, actually, unless they want to, a lot of the EU-derived legislation may fall away. So that would cover things like the agency workers, the working time regulations, fixed-term employee regs, things like that. Now, that's quite big. Do I, sitting here, expect that the government is just going to abolish some of the EU legislation that we've had enshrined in this country for a long time? No. But as we've seen, some of that working time regulations is quite complicated these days. So it might present an opportunity to clean that up. But have they got judicial willingness and time to do that? I'm not sure, or legislative time and willingness to do that. I'm not sure about that. Flexible working is changing. So flexible working is going to become a day one right rather than after 26 weeks. An employee can put in 2 requests rather than 1, response time shortened, and some other tweaks to this. So this is undoubtedly going to come. Is it going to change everything? No, it's still only a right to request to work flexibly. It's not the right to work flexibly, but they are making it more available to more people and slimming down the process. The 8 reasons to say no, should you wish to say no, will still be there. And then lastly, we've got various members' bills that are coming through. Greater protection for women who are pregnant and on maternity leave. Their protection is going to start slightly earlier and extend slightly longer. Greater prevention of harassment, a positive duty on employers in that respect, and greater statutory leave for parents of children in neonatal care. Now, I did say that was going to be a bit of a canter through. I didn't have time to go into this in a lot of detail, but hopefully it's whetted your appetite for what's going to come and given you a bit of an indication that we've had some significant decisions this year. So I'm now going to hand over to Pete, who's going to talk to us about data protection, which will obviously be far more interesting than anything I've just said in the last 15 minutes. Isn't that right, Pete?
I'm not going to claim that, but thank you for the intro. So I am similarly, though, going to not attempt in the 10 minutes roughly that I've been allocated to cover everything that's happening in data protection now, or that will be coming in data protection. So this is a bit of a greatest hits based on things that are happening and things that we've been doing as a result of what's been happening. So I've categorized it broadly in three areas. So I've done international transfers, what the ITO has been up to, and what's happening with the government. So on international transfers, I'm hoping for people on the call, a lot of this will be recap rather than news, particularly because I suspect people will have been busy responding to some of this stuff. Certainly clients we've been working with have. So first is around Schrems 2. And the reaction to that case in a couple of areas. You may remember this was the challenge to the basis for using standard contractual clauses and international transfers. That's resulted in various streams of activity, one of which has been to replace the old standard contractual clauses used for international transfers of personal data from the EU. The European Union issued some new standard contractual clauses that people have been using for some time now, and there was a sunset again date put on the use of the old clauses. So whilst people should have been using the new clauses for new contracts for a while now, they were also supposed to replace any contracts that incorporated the old SCCs for transfers from the EU by 27th of December. So we've been working with a number of clients to try and do that as efficiently and effectively as possible. I think there's a general recognition that there might be some left for people who haven't got to them, but if you've done your best, I suspect that the regulators will be reasonably sympathetic. But if you haven't done anything, then you might want to start having a look pretty sharply. The other related area is around transfer risk assessments, which is where, rather than just make an international transfer, rely on the standard contractual clauses as people had been doing, people should be looking at the circumstances of the transfer, the nature of the data, the nature of the country the data is going to, the protections in place, the laws in that country, and so on. So a number of clients we've been working with have been going through transfer risk assessments to consider the circumstances of those transfers. The Information Commission's Office has prepared a helpful tool to use with doing transfer risk assessments. People often do them alongside doing data protection impact assessments. So again, those need to be proportionate to the nature of the transfer that you're doing, but you should again at least be doing something and recording what you're doing. And again, linked in terms of international transfers, we've got the new UK data transfer agreement and the UK addendum that can be used with the EU's standard contractual clauses. That those should have been in use again since September. People shouldn't be using the old standard contractual clauses at all for new contracts anymore. And there's a little bit longer for transfers from the UK to replace the old SCCs for existing contracts. That's through till March 2024. So our experience is that, particularly for multinationals, people are generally doing them all at the same time. So rather than doing the kind of EU ones now and the UK ones later, they're just updating all their contracts as appropriate. So again, if that's not currently on the to-do list, it's probably one for early next year. And lastly, a little bit of good news on transfers to the US. Earlier this year, the EU-US data privacy framework was agreed, and the Biden administration signed off an executive order in October setting up some arrangements to allow data to flow from the from the EU to the US. And we heard this week that the European Union's looking at moving towards an adequacy decision for transfers to the US on the basis of that. It will only be for people that sign up. It won't be for all transfers to the US, but it will be a little bit like the old Privacy Shield. We shall see whether Schrems has a go at that as well. That's one for the future. So that's it on international transfers. If you wouldn't mind moving to the next slide, James. So ICO codes and guidance. ICO has been busy issuing various bits of guidance and codes over the course of the year. I haven't tried to cover everything. This is just some of the ones that we've seen hitting our desks more often than others. So we have the Children's Code and Data Sharing Code. Both came into force in 2021, but we've still seen people responding to those during the course of 2022. The thing I was going to mention on the data sharing code is, I think, as a reminder, the thing that comes up most often for us is the data sharing code is addressing controller to controller data sharing. And if we're honest, it's really looking at data sharing where the data sharing is inherent to a particular project. And so the participants in that project or that arrangement each have a role in the use of that data. Sometimes people are overzealous in implementing the code in ways that has unintended consequences. For example, restricting a controller in its use of the data, its own data that it's been sharing with a third party. So certainly the code has got some great best practice stuff in there. That there are some good guidance on what to put in your contracts, but also tread carefully and don't just assume that it's throw the kitchen sink at every data sharing arrangement under the code and that will do the job, because it doesn't always. There's some useful new direct marketing guidance from the ICO, so including a guide for SMEs who I think sometimes struggle with the complexities of it, a checklist around what you need to do to comply, and some analysis on lawful basis. There's some useful research guidance that came out from the ICO earlier this year, which sort of broadly follows the European Data Protection Board's previous guidance, but is helpful in terms of research context around, for example, the role of the various parties in terms of who's a controller, and also again looking at things like lawful basis. So I'd say we've seen that must be very helpful when advising people in life sciences education and people running research at their sites, hospitals, and so on. So that's a useful one to have a look at. We had draft guidance published earlier in the year. There was a consultation on it. At least as far as I'm aware, we haven't then had updated guidance issued, but there may well be in due course. Watch this space on that. And finally, just going to mention there was also a code on journalism has been under consultation, and also new draft guidance on privacy enhancing technologies. I only mention those to illustrate the fact that the ICO is still churning stuff out, so keep an eye on what's coming through. And then my last slide is just a little bit about what the government's up to. So first, on the government issuing a couple of weeks back a procurement policy note around data processing arrangements in particular, including some model controller processor clauses, which central government executive agencies, NDPBs, are supposed to be using those model controller processor clauses adapted as appropriate for particular contracts. So even if you're not a government body that was caught by that, you may either find that you're the recipient of those clauses, so useful to be aware of why they're being used in that form. And obviously, if you are advising government clients, then you'll need to be aware of those new clauses and using them where appropriate. And the last thing I thought I'd mention was a sort of non-update on what next in terms of the Data Protection and Digital Information Bill. So if you remember, this was where the government was looking at opportunities to reform data protection in the UK post-Brexit, looking at things around simplifying governance, removing the obligation to have a DPO and so on, relaxing the rules on cookies, increasing the fines under the PECA for email marketing and so on. So there was a draft bill. They were supposed to debate it again in September. That was postponed. It's a bit of a watch this space, and as James covered earlier with the sunset of European laws, we don't exactly know how that's going to play out in the data protection context yet. So we shall see. I think, given that I mentioned adequacy earlier, we want data to keep flowing between the EU and UK. We're not expecting data protection to be junked altogether, but whether it's the combination of this bill plus those sunset provisions, we're not exactly sure what the future holds. And on that, I will hand over to Rachel.
Thanks very much, Peter. I wanted to use the commercial disputes slot today to talk about recent developments without prejudice. Both for private practice lawyers and those working in-house, there have been some key developments that we all need to bear in mind. I mean, I think it's fair to say, how often have we told people within the business or our clients to mark documents without prejudice to seek to keep them essentially off the record without really thinking about what those documents are and what they mean. And recent warnings by the SRA mean that we all need to be a lot more careful about how we use the banner without prejudice. So just as a recap, onto the next slide, just to have a quick chat about what without prejudice is. As I'm sure you're aware, it's essentially a doctrine that prevents written or oral communications between parties which contain a genuine attempt to settle from being put before the court as evidence of admissions against their interests or concessions by them. And so generally, where the WP rule applies, the relevant statements won't be admissible, either in the substantive dispute or on the question of costs. And for example, this is typical of statements made during a mediation process. However, where the communications are marked without prejudice save as to costs, they will not be admissible in the substantive disputes, but they may be admissible on the question of costs. To give an example, if a settlement offer is made at an early stage in the proceedings that's ultimately exceeded at trial, then a party might then seek to use the existence of that offer to argue that a larger proportion of their costs should be paid. Now, as you're probably all aware, the rationale for the WP rule is to enable parties to engage in negotiations with a view to settle the matter outside of court, without fear that what they've said will be used against them in the proceedings if the matter isn't resolved. So it's almost a public policy rationale. So moving to the next slide, why are we talking about this matter now? Well, it has been recently become a particular area of contention, which has resulted in a review and a warning notice being issued by the SRA. As you may be aware, recently a former tax partner of Clifford Chance and head of Tax Policy Associates, Dan Nidal, regularly publishes articles on his blogs. One of those recent articles raised issues with the tax affairs of the former Chancellor of the Exchequer, Nadeem Sahawi. And in particular, Nidal alleged that certain answers given by Sahawi about his affairs were provably false and contained a lie. And you can see the quote on the slide there, which is taken from the article in question. Now, clearly, Sahawi did not enjoy being called a liar. So in response to the blog post, he instructed lawyers, Osborne Clark, to send Nidal a letter inviting him to retract his allegations, in particular the allegation that Sahawi was a liar. And this letter was marked confidential and without prejudice. And you'll see from the next slide what Osborne Clark said and how they sought to justify marking the letter without prejudice. They said, I've marked this email without prejudice because it's a confidential and genuine attempt to resolve a dispute with you before further damage is caused. Our client wants to give you the opportunity to retract your allegation of lies. They also said, you have said you will not accept without prejudice correspondence. It's up to you whether you respond to this email, but you are not entitled to publish it or to refer to it other than for the purpose of seeking legal advice. That would be a serious matter, as you know. So Nidal didn't really take kindly to this communication, and he got the bit between his teeth, and he referred the matter to the SRA on the basis that, amongst other things, although the letter was marked without prejudice, it contains no concessions on Sahawi's part or any offer to settle. And as such, Nidal claimed that the letter was designed to intimidate him and was an attempt to pressurise him to withdraw his claims. He said the conduct amounted to the catchily named a SLAP, which is a strategic lawsuit against public participation. And in his letter to the SRA, Nidal pointed to case law which provided that the WP rule cannot apply to a communication where a party simply sets out its case or asks for a concession but doesn't offer one of its own. Nidal also, contrary to Osborne Clark's request, did not adhere to non-publication, and he put the letter on his blog. This then led to Osborne Clark sending a further letter, again marked this time not for publication. Nidal raised this further issue with the SRA. We're focused on without prejudice today, so we won't go into the arguments around this additional letter and the request that it was not for publication. But needless to say, just stating that a communication is not for publication is unlikely to impose confidentiality obligations on another party. So what happened as a result? The consequence of Nidal's campaign is that on the 28th of November this year, the SRA published a warning notice. And that notice is relevant for all firms and individuals that are regulated by the SRA and who manage dispute resolution and pre-action advice. So it is likely to be relevant for any in-house advisor regulated by the SRA who oversees any pre-action skirmishes with suppliers or clients or competitors, which may of course be any number of you. Now, the warning notice indicates, among other things, that regulatory action could be brought against those who engage in conduct that amounts to SLAPs. And the notice confirmed that the SRA expects those it regulates to be able to identify potential SLAPs and decline to act in this way, and advise clients, or in your case, people within the business, against pursuing a course of conduct, including making threats in correspondence which are unjustified or illegal. The notice also provides a list of behaviours it considers are commonly associated with SLAPs, the most relevant of which for today's purposes being sending correspondence with restrictive labels, such as without prejudice, that are intimidating and incorrectly applied. So we move to the next slide. What does that actually mean? Helpfully, the SRA warning notice does provide a little more detail. With regard to without prejudice correspondence, the SRA confirms that you must take care not to mislead the recipients of your correspondence, in particular, where the recipient is a litigant in person or in some way vulnerable. Notably not the case with NIDL, but in any event, a principle that you should maintain throughout. So you must take care not to mark your correspondence without prejudice if it doesn't fulfil the requirements of that label. Clearly, Osborne Clark's letter did not offer any concession and only argues the Harley's case and should not have been marked without prejudice. So how do you avoid getting it wrong? A few do's and don'ts on the next slide. Firstly, do take a look at the warning notice. It also covers other matters which you should definitely be aware of. Second, next time you're advising somebody to include without prejudice on a communication, have a really good think about whether it is in fact a genuine attempt to settle, contains any concessions, because you could come in for criticism if it doesn't. And a don't use WP as a mechanism for hiding, intimidating or threatening correspondence. A good rule of thumb in all communications, I always think, is whether you would be happy for a court to review what you've said, regardless of whether it's marked without prejudice or not. If actually there are things in there that you wouldn't want a court to see because they stray across that line, then perhaps think again. If you would be happy for a court to review, other than, of course, because you're making concessions, then you're probably on the right lines. So that was just a quick run through there of the recent developments on without prejudice, and a cautionary tale, I think, for everybody to bear in mind.
Thank you, Rachel, very much. There's just one question for you, which is about whether the restrictions that you've just talked about would apply to a chartered surveyor who uses such language, perhaps, or threats, I'll put it that way, in negotiations for lease renewal.
Look, so at the moment it just replies, the warning notice only has gone to those who are regulated by the SRA. So if you're not regulated by the SRA, then it doesn't strictly apply to you. That said, I think it's a cautionary tale and useful best practice in any event to keep these principles in mind in whatever you're doing.
Good advice, thank you. Well, you've all been a marvellous audience, but we've obviously answered all your points because we've had no other questions that we haven't answered already. So without further ado, I'm going to say thank you to all of our speakers, to Rachel, Peter and to Jayne. You can all return to throwing snowballs if you want to, those of you who have snow, or do some work. I'd like to remind everybody that please do attend the January quiz, which will be great. To see you there, to remind you that there will be a feedback form pop up as you leave. Do complete that, please complete that, and to say have a wonderful festive season. Thank you very much, everyone, and we will see you soon.
Thanks so much.
Thanks all.
Thank you.